Welcome back, everyone, from lunch. I'm Mike Franzak with FMCS, and I will be co-facilitating with Cindy Jeffries this afternoon. We want to let folks know that there will not be public commentary today, as we did yesterday and in the prior sessions. And I'll do a quick review of what I believe is our agenda for today, for the remainder of the afternoon. So the first thing we're going to do is review the FEL language. I believe from there, the department's going to make a statement in terms of our overall thought, or the overall thoughts in terms of the consensus moving forward in terms of final consensus. We'll run through each of the sections in terms of a final consensus check. And as we go through that process, when you vote, we're going to ask you to, when you're voting thumbs up, thumbs down, or thumbs sideways, thumbs down, we'll ask you to hold that so we can make sure we record what everyone is indicating in terms of their vote for the respective sections. We'll take any new comments at that point. And if not, then we'll move into the next section and run through all the sections so we make sure we have time. We'll take a break if time avails, and then we'll get into the hardship discussion. At the request of the non-federal negotiators, FMCS did invite two researchers to make a 15-minute presentation to the committee on their research on the hardship topic. And that will be done in the last section of our time today. I believe that is everything. There is one last thing we wanted to add, and we'll reiterate it again. When we go through the consensus decision, final consensus decision making, if we do reach consensus, and when we do reach consensus on the sections, that regulatory language will flow then into the language that the department presents. If there is not consensus, then that language is subject to change at the discretion of the department. All right, so I believe that takes care of all the preliminary matters to understand and our agenda for this afternoon. Anything else from the department as we begin to move forward?
Yes, Mike, if I could just add, I want to remind everyone that when we do discuss final consensus checks, that all of the sections in advance of subpart G, the new 30.80, will be one consensus check will be taken, final consensus check will be taken on that language. And then after that, all of the individual sections of regulatory text will have individual final consensus checks.
Thank you, Tammy. John, you have your hand raised?
I do. We would like to have a very brief 5 to 10 minute caucus with the department about a pending matter. And I can tell you who I'd like to be in the caucus. The department gets to, they can put in as many folks as they want. I would like the caucus to be myself, Yale, Kira, Jessica, Wisdom, Jaleel, and me.
And Mike, from the department, that would be Ben, myself, Toby, Soren, Gen Z, and Brian Siegel.
Okay, let me name everyone again to make sure we have all the correct folks for the caucus. We have John, we have Yale, we have Kira, Jessica, Wisdom, and Jaleel for the non-federal negotiators, correct?
I think that's everybody, yes.
And then Ben, Tammy, Toby, Soren, and Brian on behalf of the department.
And Gen Z.
Gen Z, thank you. All right, how much time do we want to allocate for the caucus?
10 tops.
10 minutes?
And we may be back before that with a bit of luck.
Okay, so let's aim to, how about 1:15?
That works.
All right, Brady, can you create the caucus?
Yep, folks should be seeing
Well, it may take me 10 minutes to figure out how to get in the breakout room, but that's a separate problem.
we aim to do that a little bit more expeditiously.
Oh, look at that. All right, here we go.
welcome back from our short caucus. So it's my understanding that part of what was covered in the caucus will be discussed as a part of the hardship discussion later this afternoon. So if there isn't any further discussion, we'll get on with the agenda as planned. Good? All right. Okay. So what we were planning on doing was the FEL language review. So I'll turn it over to Tammy for this section.
Thank you so much. Will my screen sharers please share the FEL language? Wonderful. We have made a number of changes throughout this section. A lot of these changes are focused on process. Our commercial FEL regulations concern loan holders beyond the department, so we wanted to make sure the procedures for how this would work are clear. So for instance, we have extended the timeline for certain processing requirements. We have made it clearer that lenders would be compensated for the full outstanding balance of the loan. We have also added procedures clarifying how the secretary would work with guarantors and lenders to deliver these benefits to borrowers. We have also updated the types of borrowers that would be captured under a waiver here. In addition, we have kept the provision related to borrowers who entered repayment 25 years ago. This is similar to what we proposed for ed-held loans, but we did not think it was appropriate to go to 20 years here because that forgiveness timeline is not available on IDR plans that apply to the FEL borrowers. We also kept the provision about including borrowers who are eligible but have not applied for closed school discharges. We also added an additional category for borrowers whose institutions lost federal aid due to high cohort default rates. Calling this out explicitly because there are other student outcome measures that affect direct loans, such as gainful employment, which would not exist for FEL loans. As we indicated in the last session, we removed the provision related to borrowers being eligible but not having applied for IBR. We do not think we would have the data to identify these FEL borrowers under IBR. And the first instances of IBR forgiveness in FEL are still a few years off. There was a request to retitle this section to mention that this is for commercial FEL. While we understand this confusion as a standalone section, this would not be necessary when the rule is promulgated. This information, this section would be included in the commercial FEL regulations found in 34 CFR 682. So the coverage will be clear. The red line text representing all these changes should be shared, and we would like FMCS to have a temperature check, please.
Great. Tammy, were we covering part B in this section, or is this A, C, D, E, and F first?
So what we are going to do here is look at A, C, D, E, and F as one section. We've removed paragraph B, and we'll discuss that separately. Not discuss it, but we'll take a temperature check on that separately. So if we could separate the two temperature checks to be A, C, D, E, F, and then B all by itself.
Thank you for that.
Thank you, Michael, for that clarification.
Yes. All right. So any initial discussion or questions around A, C, D, E, and F before we take a temperature check? All right. If not, with a show of your hands, thumbs up, sideways.
I'm sorry, Mike, can you just clarify one more time? We're still within the FEL section, not, okay, thank you.
FEL
Yes.
only.
682-403.
All right. Then yes, we are only on the FEL section A, C, D, E, and F. We're holding on B for the moment. All right. So what if we take a temperature check on those sections with a show of thumbs? Okay. So the only dissenting thumb I'm seeing is from Jessica Ranucci. Is there anyone else that I'm missing? Okay. Any questions or comments about or concerns relative to that? temperature check. Jessica,
Look, I don't mean to be annoying here, but I'm unpersuaded by your reasoning that a court could not read this to cover department held fells. It's right next to the provision, for example, that's about like disability discharge, which applies to department held fells. Like I don't have a substantive disagreement here. I don't want you to accidentally write reg text that would take away the ability to give to relief to many, many, many borrowers who have ed held fel loans just because you called it the wrong thing. So I don't really care how you do it. And I think if you have to do it in the preamble, I guess that you could make that clear, but I would strongly encourage the department to clarify in some way in the reg text itself that if a borrower has a department held fel and thus would be eligible for waiver under the provisions we've spoken before and the text of this provision, that the fact that the basis upon which they receive the waiver is not listed in the commercially held fel section is not a reason that they can't receive the waiver under 3080. So I think there are a lot of ways to clarify it. I think the title is honestly the simplest way, but I'd be happy to do any. I would worry that without being clearer that people, a court could misread this and not follow through with what you intended to do.
Jessica, would you put those two ideas in a chat message?
Yeah, I think the department knows what they are, but sure.
Any other discussion or question on A, C, D, E, and F of the fel language? Scott Buchanan.
Yeah, I would just say, briefly on these particular sections, I think on the claims process, certainly appreciate the department's on consideration on this. We'd like to continue to work with the department on some of these provisions because I think, as we sort of dissected some of the complexities that might come in implementation, we'll still need to work on that. But I want to acknowledge we appreciate sort of the department's openness to work on those things. I think on sort of section F, I will highlight that today there's a process to do partial forgiveness as opposed to the methodology that's contemplated in F. And I think we'd like to hopefully have some discussions with the department. And as you work on the final rule, there might be an opportunity there to address that. On the sections, and I think those are sort of the issues that we'd like to continue to see if there's forward progress on that can be made in terms of further clarifying and providing some definitional and technical changes there.
Tammy?
Yes, Jessica, we can include a statement in the preamble. The regulations themselves do not govern ED's actions on ED held loans, so we cannot fully take care of what a court may do, but we can address this as clearly as possible in the preamble language.
Jessica, do you have your hand raised again?
Yeah, I understand that. The language that concerns me, for example, says the secretary determines that a FEL program loan qualifies for a waiver and then under certain situations. And that's not actually what this regulation is doing. It's determining when certain FEL program loans qualify for waiver. And then there's a different regulation that shows when other FEL program loans qualify for waiver. And I just think the preamble is fine if that's the best I'm going to get, but I would just strongly encourage you to put anywhere in this regulation something that clarifies that it is not it's not limiting relief as to other FEL loans. And I think that it would be extremely simple and just to put anywhere here that it does not apply to loans owned by the department. Again, I think the title is the simplest, that you could do it anywhere. I'll stop now.
This whole section, Jessica, is in subpart D of part 682, which is the FEL loans by guarantee agencies. So it's only commercially held FEL loans. So that does cover, and again, we would be, we could make sure that in the preamble that we clearly call that out. But I don't think, because of where this is located and it's only about commercially held loans in the FEL portfolio, I don't think that I just think it's covered because of where it's already located in the amendatory text, or where we're proposing to put it in the mandatory text.
I don't really see a countervailing harm here, but I hear you. I think it's like not the clearest that it possibly could be. I don't really like, maybe you have some reason I don't see that it would,
Okay.
you would be afraid to change the title, but I would just encourage you to take another look. Thanks.
All right, I think your message has been noted, Jessica, by the department. They will take that under advisement. Are we okay to transition then to part B of the FEL review, language to review? All right, Tammy?
I think we just need to go ahead and do that temperature check and then get discussion on that.
Okay. All right, so we are looking at section B. Jessica has her hand raised.
All right, but this one is a legitimate clarifying question. Tammy, I thought that I heard when you spoke in the introduction that the subpart provision B did not apply the 20-year time limit to any FEL borrowers, but I think that I see that in here, and I just was wondering if you could clarify that. Maybe I misunderstood.
I'm trying to look at this, Jessica. Give me a second. So I have in my notes that we kept the provision related to borrowers who entered repayment 25 years ago.
Right. I don't think it doesn't look to me like that's what the reg text that was sent says.
Let us
Again, I
take a
could
look
be
at that
mistaken.
and we'll circle back to you. Thanks for bringing that up. Let us get some eyes on that. I can't do both, unfortunately. I just can't do that. I'm not that talented, but we'll get back to you on that. Thanks so much.
All right, thank you. Thank you for the clarification and answer. All right, so we were then circling back for a temperature check for B, part B. Scott,
Well, now wait a minute. If we're not sure what language is in front of us, how is the language that was shared last night, the language that we are voting on? Okay, so there's been
Yes,
no.
sir. I just don't have it in front of me, so I can't speak to it.
I can speak to that, Jessica. You're talking about B1, right? Percentage repayment 20 or 25 years ago.
Right.
Yeah, no, it's in there. Apologies if we weren't clear about that. The language we have from last night that we shared with negotiators last night is the language we're looking at now.
B1, correct?
Correct.
Mhm.
clarify, do we want to take these B1 first as a temperature check, B2 as a separate temperature check, or do we want to take B1, B2, and B3 all together?
I would prefer we do them all together unless the committee has a reason to do them separately. But I believe we still have some other hands up.
Okay. Let's go with Sherry. Damage.
Tammy, did I understand you to say that you don't have it in front of you? I wanted to see it again before I voted.
The screen sharers, would you put that up on the screen? I have it, it's just on a different screen, but yes, here it is. B1 right here. Can you see that? Is it showing, correct? Okay.
Yes, I can see it. Thank you.
Yes, ma'am.
With that clarification, are we okay for a temperature check now, or Lane has hand up? Lane, go ahead.
Thank you. I thought I heard that 20 years was not an option for this section, but then 20 or 25 years is in this language. So I think I'm just a little unclear on that. Could we get a little bit of additional information about whether it is 25 years or 20 years, or if that was the intention? Anything about that would be very helpful before we do the temperature check.
So if you look at B1, the title of B1 is first entered repayment 20 or 25 years ago. Romanet 1 talks about on or before July 1, 2005. Romanet 2 talks about entering repayment on or before July 2000. So there's two separate, that's why it's 20 or 25.
So it's just two separate dates that would begin at.
So if you look at Romanet 1, the secretary may waive the outstanding balance of a loan if the loan first entered repayment on or before July 1, 2005, and the borrower only received loans as an undergraduate student or a federal consolidation loan or direct consolidation loan that repaid only loans the borrower received as an undergraduate student. And then Romanet 2 is the secretary may waive the outstanding balance of a loan if the loan first entered repayment on or before July 1, 2000, and the borrower received loans other than loans received as an undergraduate student or a federal consolidation or direct consolidation loan that repaid loans other than loans the borrower received as an undergraduate student. So it is two separate timeframes based on undergraduate student and the federal consolidation loans versus other loans received.
Okay, so what I'm hearing is that this is the same as it is for direct loans. I thought that there was not that option because of the IBR timeline. Okay, I must have misunderstood something that was said earlier. My mistake. I'm sorry.
Can we go back to the full screen of everyone? All right. Are we ready then for a temperature check for B1, 2, and 3? All right. By a show of thumbs, are we in agreement? B1, B2, and B3? This is where I'm identifying who's not in consent. Scott Buchanan, Jessica Renucci. Anyone else? Okay. All right, so does that cover all our FEL language for review, Tammy?
Yes, sir.
Okay. Okay, so with, a couple comments. Or Scott Buchanan?
Yeah, I just want to comment and provide some context about sort of our position on this. We've been consistent and clear through these sessions here. The department needs to ensure that whatever proposed regulatory benefits it develops via this process can actually reach borrowers and not just be headlines. To withstand judicial scrutiny, the proposed regulations must be consistent with the Higher Education Act and legal precedent. Whether one agrees or not, the courts have been pretty clear on this. Some of the proposed language in both this and previous sections, counting time in both default and with the previous loan now paid in full via consolidation is in repayment, is contrary to the Higher Education Act and the department's own precedent. For previous sections, those are really matters for Ed because Ed has declined to provide their legal reasoning despite negotiated requests for it. But our constituency has clear line of sight on this section. And the department has only ever considered time and certain deferments and forbearances as qualifying towards forgiveness under expired and extraordinary HEROES Act authority, which itself has been called into legal question. Also, a consolidation loan is a new and discrete loan agreement with new and discrete terms. The Higher Education Act mandates that interpretation, and the department's own consolidation website today affirms it. Second, and I think important, is this proposed rule suggests that time and repayment, absent any indicator of hardship, is reason alone to forgive a loan. That is in direct conflict with the repayment plans Congress wrote into the HEA, and all without consideration today of individual burden or hardship that the waiver and compromise authority certainly requires. Forgiving a consolidation loan that has a 30-year term, for example, that's only been in repayment for 14 years is in direct conflict with the HEA. We've raised these issues before and are ready to work the department to identify the individuals who really need help and how to target that assistance to those who need it. We've been doing that through IDR and other plans that have provided billions of dollars in forgiveness and will provide billions of dollars in forgiveness. But we've also seen and heard from borrowers how false hope has led them to make life-altering choices based upon past guidance and promises from the department that have been struck down, leaving them worse off. The government can't make the same mistake. Some of these proposed regulations are unlikely to stand legal scrutiny, and that's the reality that we must face. Given this rulemaking is unprecedented in scale, potentially costing hundreds of billions of dollars, more work needs to be done to take those concerns and dozens expressed by other negotiators to heart, while redrafting so these benefits can actually reach borrowers. Look forward to working with the department, and like I said, on these other provisions. We appreciate the continued conversation, and we'll continue to work on things like the claims filing process and other things where we think there's still an opportunity to give more time to process those things so they can be done timely.
All right. Thank you, Scott. Jessica?
Just briefly, I think that this provision has the same cliff problem as we talked about this morning with the same language.
Okay. Is there anything else then on the FEL language review before we move into final consensus checks on each of the individual, the sections as we've identified? Tammy?
Actually, Mike, I think I'd like Ben to jump in. I just would like him to clarify if we needed to discuss B2 and B3 separately. But if he has anything to add, I'd like to ask him to jump in now and add it.
Ben?
Sorry, I think they got messed up with our behind the scenes instructions, which we were supposed to do B1 separate from B2, separate from B3 for discussion. So if we can do, I think we heard from Scott on B1, and I think we heard from Jessica on B1. So if we can talk about B2 and then B3 separately, please, I would appreciate that.
Okay. All right. So moving then to an individual discussion on B2. Is there any comments or questions on that one before we go to a temperature check on B2 specifically? Jessica?
Yeah, I noticed that you changed last night the not successfully applied for language in a different part, and I think that that might do well here also.
Thanks, Jessica. That's helpful. We'll take a look at it.
All right. Temperature check on B2. So we're looking at these B sections individually. So we now, that the prior one we can consider that was B1. This will be B2 specifically. So with a show of thumbs on B2, can folks identify with thumbs where they are on consensus with B2? I did not see any dissent. Looks like the temperature check on that one is we are in consensus. Moving next to B3. Oh, Cindy?
Mike, can I just clarify that?
Yeah. Waukesha, for voting purposes, you're welcome to turn on your video so we can see you as well.
Mike, her camera's not working at the
Oh.
moment, but she is here.
Okay. All right, thank
She put a
you.
message in chat.
Thank you. All right, so we are moving then to B3 then. All right. Our temperature check on B3. Show of hands, the thumbs. Okay, I see one thumb down. Thank you, Waukesha. Scott Buchanan, I believe, was in dissent. And that was the only one. Any comments or question on B3?
And I just want to clarify, I'll just make a comment here. If that's, sorry, I didn't raise my hand, but
It's okay.
all right. I think, listen, this is conceptually, we are very supportive of this, where this policy is going here. I think we have some technical issues that hopefully, and we can work with the department prior to the proposed final rule. But again, I think we could work through those. I think it's a lot of this is about the claim filing timing, sort of how do we handle that, and then what potentially deal with uninsured loans and some other very technical things. So again, I just want to state that as a concept, we look forward to working with the department on this as they proceed towards a final rule.
Thank you, Scott. Jessica?
Yeah, Scott, are those concerns about cohort default rate specifically, or just about something more general?
Well, I think it's about which specific loan populations would be included, whether it's, cohorts. And I appreciate the department has offered some clarifying language, but I don't think it's sort of sufficiently gets us where we need to about which pools of loans and what dates would be affected. For example, if a school loses eligibility because of that cohort default rate, if there was a loan made after that date. I think the language that the department has offered here is moving towards solving that issue, but we have some other questions about loans proceeding to that during the process of when a school might have been losing eligibility, to make sure we're exactly clear what cohort of loans are included in that bucket, and how far back we're going to go in terms of application.
Okay. Anything further discussion-wise on FEL before we would transition to our next section of the agenda? All right, so by way of review, I believe that covers all the initial review of the text language and temperature checks. So what we would do now is to move to final consensus checks. Tammy?
We need, the department needs to caucus, please.
Okay,
10 minutes.
10 minutes. Brady, can you help get them set up for the caucus? So we will break and reconvene at roughly 2 p.m. Eastern.
Yes, please. That would be Ben, me, Genevieve, Brian Siegel, Toby Merrill, Soren Lagarde. Is that everybody? That's everybody.
I think you should be just about all set.
Thank you, Brady.
And if you just go to breakout rooms at the bottom, you should be able to join.
It looks like I'm being added to the breakout room. Am I supposed?
So the breakout rooms need to be kept open for the purposes of the live stream. So I just moved you out of the Department of Education breakout room because
Okay.
it's a weird Zoom quirk. Sorry.
That's okay. So I can say not now to this one.
Cindy, did you have a comment? Your hand's raised.
Yes, since we've got a matter record who's in the caucus, can we pause the live stream?
Welcome back, everyone. We're returning from the department caucus. And it's my understanding that the department may have some alternative language or language to share on the FEL. So I'll turn it over to one of the Department of Ed officials.
Hi there.
Thank-
Yes, I'm gonna turn it to Ben. Is he on camera? Oh, there he is. Ben, would you take it over?
Yep. So thanks for bearing with us for a second there. As some of you noted, there was a little bit of a disconnect between the way Tammy was describing the reg language and what we sent around. We realized that in our attempt to implement the switch from saying 20 years to the date, we accidentally did parallel part of the language we did not mean to parallel. So we did mean for this section to be just 25 years. We understand there's sort of concerns from multiple parties as the way it was drafted before, but we did mean for this just to be 25. So we have fixed that here. The second thing, if you scroll down to paragraph 2, we added in the language that Jessica sent, or sorry, we had added last night on the other section around either has not applied or has not successfully applied, just clarify that section. So that language now parallels what we have shared. And if you scroll down to the third paragraph, very bottom. So I would just note that we tried to have this language here to sort of hint at this issue of adding clarity around the cohort default rate piece. Scott, totally appreciate that may not be fully getting the job done. Just wanted to sort of throw that out there for you to take a look at it. And since this is the last one for consensus, if it makes sense to talk about this one at all before we get the final consensus on paragraph 3, we're happy to do that.
Anything further from the department? Scott has his hand raised.
Yeah, and I just want to, I appreciate that, and just offer that probably in the consensus vote, as I was looking through, I think the concerns we have really lie in the in section D. So, and I think the change. So, I probably consensus voted on the wrong provision. So I think on the cohort default rate, sort of the conceptual issue here in 3, I think we would be sideways, not withhold consent. But it's going to be on section D that I think we still have continued challenges that we need to work through on that. So if that helps clarify. So I think, in the consensus votes or when we take those that on like B2 and 3, I think we could certainly not withhold consensus on those if there was consensus.
And Scott, just because I'm stuck on my phone because of unreliable internet, you said B1, B as in boy 1?
No, B2 and 3, we would not withhold consensus.
Yeah, sorry, but you have issues on B, boy 1.
B1, I think we continue to have, as I expressed, the legal and statutory conflict issues remain.
So I understand. I just want to make sure I had the right letters. Thank you.
Looks like Jessica has her hand raised.
Yeah, again. So now I see that you have a regulation that says we will waive department held FEL loans for undergraduate borrowers who entered repayment before July 1st, 2005, and we will waive the outstanding balance on FEL loans for all borrowers before July 1st, 2000. Maintain that's a little confusing and you should use the term commercially held, but I think on the substance, could you just explain why you're making this change only in the commercially held FEL section? Just spell it out with the IBR.
Sure. So the only IBR forgiveness plan available on commercial FEL provides forgiveness after 25 years. When Congress changed the law, they provided 20 years for certain direct loans. So we meant to have this just mirror what's available statutorily to peg off of the 25 years here. So we hadn't meant to put the 20 years here. That was a drafting mistake while we were trying to make sure that the rest of the word is matched.
Are we ready to come back to the full group? All right, any final comments on the FEL language? Lane,
I just want it to be on the record that that was what I understood from the conversation this morning, and the fact that what was in the regulatory text was different was very confusing, and I feel like that was kind of threw off this process a little bit. So just want to put that out there.
Lane, sorry for the confusion on our end.
all right. Are we ready to move to our final consensus check discussions and consensus decision making? Good. Okay, so we are going to take these in order. We started with pre-subpart G sections early yesterday. And we did that temperature check. So Tammy, did you have something you want to share?
I do. I want to kind of set the stage for our consensus, the final consensus. Committee, we really understand that you don't want any caps and you don't want any cliffs and you want greater amounts of relief. And all we can do is have differences of opinion where this is concerned. But as we shift to writing the NPRM after these negotiations, we will think about your feedback and give careful consideration for everything that's been brought forward at the table. And equally, it is important that we will have, for those areas that we reach consensus on, we will share the parts of the preamble with you. We will also have an opportunity for the public to make comment during a comment period on the notice of proposed rulemaking. So as we go into these final consensus checks, I just wanted to set the stage to let you know we've heard you and we understand where you're coming from. And we look forward to the rest of these negotiations.
Thank you, Tammy. John, you have your hand raised.
I do. I just wanted to sort of set out why I'm going to be voting certain ways on certain things so that there's no misunderstanding. I do think this is a good faith disagreement. This is not about bad faith. And I do think the proposals have some considerable merit, but cliffs and the limits are sort of, they tip it the other way for me. And I will say, and we'll come back and probably talk about this a little bit later at the end. And I know it's sort of been said before, but I just want to sort of, and I'll say it very quickly, and then I won't say it again till at the end of the day. It's particularly problematic in the absence of usable language on hardship. It's possible that hardship language could assuage my concerns on this area, but we don't have it, so I'm sort of stuck. And as I think Tammy and I have had a discussion, it's fine that we are. It's not fine, but it's not. Sometimes we don't agree, and that's just. And I am not. I'm not gonna. Get all pissy fit about it. But I will say, for me, the 10 and 20 limits and the inability to get any movement on cliffs is going to cause me to downvote a number of items.
All right, thank you, John. So we will next. Ashley has her hand raised. Ashley.
Tammy said something yesterday that has made me pause a little bit on how I'm going to vote. There are some things that I feel necessary to vote down on, and I just want to make that clear that I'm not downvoting anybody getting cancellation. I think that everyone should get cancellation. I just think that there are just language here that puts too many limits and doesn't give enough broad cancellation in some of these provisions. So I want to make that clear that I'm not against anyone getting any cancellation.
Thank you, Ashley. Kira?
And I'm just making a similar point. I think I agree with the groups that the department is targeting. I agree with the motivations that have given rise to these negotiations. However, while I'm strongly in support of discharging interest, of discharging old loans, of doing many of the things that the department has proposed today, I think the proposals on the table are insufficient to meet the crisis that is at hand. And I also, to the extent that I am downvoting, it's not a question of whether or not the population that would receive relief under those regulations are somehow undeserving. It is simply a question of the regulation text not going far enough.
Before to go to Yael, Cindy, did you have a process piece?
No, I'm going to yield to Yael, and then I just want to set the stage with some comments for the consensus preparation.
Okay. Yael?
Thank you. In the same vein, similarly, though I will be downvoting some provisions here, I do want to say that I think the effort that the department has initiated with this rulemaking is critical. I also am not downvoting the notion that any of the individuals who would get relief under the drafted regulations should get it, but rather that many more people should get it. And that as the department goes back and considers these regulations prior to putting out an NPRM, that it take that into consideration. And to that end, the last thing I'll say is a little bit of a correction, or not correction, but a clarification on what Tammy said. Which is that, this isn't just a question of should there be cliffs or shouldn't there be cliffs, should there be caps and shouldn't there be caps. I think there's a separate question, which is, should the department give itself the discretion to be able to create tools that it can use in different circumstances in a prospective basis that will allow it to, if appropriate, and I'm not saying that it is in this context or in a different context, but if appropriate, set caps, sure. But it would do so under regulations that give it the discretion to make those determinations on a case-by-case basis and given different circumstances. And I think that's a little bit more of a nuanced point than just saying it's a question of whether or not there should be caps. It's a question of whether or not the regulatory text needs to include it. How the department then uses the regs is a different question altogether. But with that, I will stop talking.
Thank you. Cindy, do you want to kick us off?
Yeah, I just want to make a few comments here in preparation for the consensus. First, it is only primaries who are casting their position on each of these sections. So the only exception to that we currently are aware of is that Jordan Nellums will be in for the currently enrolled group as Jada is absent today. So it is appropriate for him to step in her place. That being said, if anyone who is not a voting member, which I'm not seeing any, if you could please turn your camera off so that when we make note of dissents, we are only looking through the persons with the authority to cast a vote. I also want to remind you that there is one group that is currently has no one here this afternoon to cast the vote, and that is the veterans or veterans organizations. And so according to protocol, that absence will not the absence will be the equivalent to not dissenting and will not hold up consensus on any of the items. I think other than that, Mike, we can turn it back over to you and you can start walking through the sections.
Yeah, so appreciate that, Cindy. So when we go through each of, of the sections that we've identified, we'll ask you to hold your votes by way of your thumb so that we can record them. And then make sure we didn't miss anyone in terms of any dissent. And then if we're trying to get through this quickly. So any new comments that you'd like to share, we would go with those new comments. Otherwise, we'd like to move to the next section. All right, and we're going to go in the order of numerical order. So the first section or identified sections is a grouping. It's the pre-subpart G sections that we first identified. They were the corrections to subparts A, C, E, and F. They are 30.10, 30.20, 30.23, 30.22, 25, 30.27, 30.29, 30.30, 30.33, 30.39, 30.62, 30.69, 30.70, and 30.79. All right, so that's what we are taking the final consensus vote on.
Michael,
Yes.
I have one thing that I want to mention because I believe we made one change to the reg text from last night than what was presented. I need to get back up and find that. Give me just a second.
Sure.
In 30 subpart A, section 30.1 A2, we say refer the debt to the Government Accountability Office for collection. We added the words in accordance with section 30.80 F. So I just wanted to make sure that I drew that to made sure the negotiators saw that change.
Thank you. A couple hands raised. Jessica, then Scott.
I'm not trying to be annoying, but is it possible that that's supposed to be 3070 F? I don't think there is an F on 380.
What if we come back to that
Yeah.
unless Tammy has an immediate answer?
She does not. So
Okay.
we're
We'll have
looking
to
at it.
Yeah, we'll have to come back to that one. Scott?
Listen, I'm not sure it's going to change things, but I mean, not having these changes in front of us is really kind of problematic here. I appreciate the department's under time constraints and, but
We are working to get those to you. I wasn't aware that they hadn't been sent yet.
yeah,
So,
no, I appreciate that, but it's difficult to be proceeding into voting when we still don't.
okay,
have-
well, why don't we
I'm
just take a break? Let's take a break until we can get this to you guys.
Was it? This was in the one you sent last night, though, right?
No, it's okay. Why don't we take a 5-minute break and let me make sure that we can get this document to you guys? Is that okay?
Sounds good. All right,
Thank
let's
you.
take 5 and make sure everyone has a copy of the document as sent. Can we go off live feed? welcome back from the caucus break, and we are going to proceed with our agenda. I'd like to first, though, turn it over to Tammy for a statement.
Great. First of all, thank you guys so much for keeping us straight in all of the changes. Last night, the version that you received last night, there have been two things from that version that have changed, and there's nothing else that has changed. That is the 30.70, not 30.80, that we referenced just a bit ago, and then the FEL changes that we went through in B. The document that you have references everything from last night, but those two additional changes. So you should be able to follow along now, and hopefully that will eliminate any excess confusion. And thank you so much for your patience with when we got this information to you. We really appreciate it.
Thank you, Tammy. So everyone should have received it in an email for the proposed regulatory language. FMCS is also working to put it in the chat as well, for as another resource possibility. All right, with that, are we ready to proceed with our final consensus check? All right, sounds good. All right, so we are again looking at a grouping first, which is the pre-subpart G sections. I won't go through them all again, but as we identified earlier, they're all the subparts, the corrections in subparts A, C, E, and F. All right, so what we're going to do is we're going to ask you as we're voting in this section, we're going to ask you to show your thumbs and hold them so we can make sure to identify everyone so we're not missing anyone. So if you would, on this particular pre-subpart G sections, could you raise your thumbs for voting purposes? This is final voting on this subsection. Sections. All right, keep them raised if you would, please. So I'm just identifying those who are in dissent, okay? Kira Taylor, John Whitelaw, I believe that's everyone. Am I
It looks
missing?
like Ashley's thumb is down.
Okay, Ashley as well, sorry. Are there any new comments? Again, we're trying to expedite things. We've understood all the concerns that have been raised throughout the past 2 days with respect to major concerns that folks have. So we're just looking for any new comments with respect to this particular section's vote. All right, seeing none. If you do have anything, please raise your hand, the virtual hand. All right, seeing none, I believe we're going to go next to the subpart G sections, which begins with, I believe, 30.80. All right, so 30.80, that is the waiver of the student loan debts. All right, by way of thumbs for consensus, can you raise your thumbs and vote on section 30.80 as a final consensus check? I do not see anyone in dissent. So I believe that has full consensus. Congratulations. All right. We are next going to 30.81, section 30.81, which is relief for borrowers on an IDR plan. Everyone have identified the section we're voting on, section 30.81. Okay, so by show of hands for a final consensus check or vote on 30.81? Can folks raise their thumbs? All right, so I'm just going to identify those who are in dissent. Jessica Renucci, Yael Chevet, Kira Taylor, Ashley Pizzuti, John Whitelaw, Richard Haas, Wisdom Cole. I believe that's everyone who was in dissent.
Mike, if I may, your audio is extremely weak when you're starting out and it's really hard to hear. Okay.
Okay.
Thanks.
When you're closer to the microphone, it's totally fine. I think it's just distance.
All right. Well, please, thank you for pointing that out. Please bear with me. I'll speak louder and slower, if that's okay, and I'll sit closer to my computer. You'll just have to see my face closer to the screen. So please bear with me. All right. Okay. We are moving next to 30.83, correct? Or I'm sorry, 30.82, sorry. 30.82 relief for Bowers on save plan. All right. By show of hands and thumbs, please identify your final consensus check on 30.82 relief for Bowers on a save plan. Thumbs? All right, I'm going to identify those in dissent. Jessica Renucci, Yael Chevet, Kira Taylor, Ashley Pizzuti, John Whitelaw, Richard Haas, Wisdom Cole, and I believe that's everyone in dissent. All right. Next, we have 30.83. 30.83 is what we covered in part this morning. I don't have the name of the section in front of me. Please bear with me.
Waiver when a loan first entered repayment 25 years ago. I
Great.
believe.
Thank you, Tammy. All right, so voting on 30.83. Jessica has her hand raised. Jessica?
Sorry, to 20 or 25 years ago, right? I'm not trying to be, just after that last conversation we had, this one is 20 or 25 years ago, right?
Yes.
Okay, with that clarification, are we ready to vote?
So Michael, it's waiver when a loan first entered repayment 20 or 25 years ago in section 30.83.
Thank you. All right, ready for a vote? All right, show of thumbs in consensus. What I have in terms of identifying who is in dissent: Kira Taylor, Ashley Pizzuti, John Whitelaw, Lane Thompson, Wisdom Cole. Did I identify Scott Buchanan yet? Those are all folks who were in dissent on 30.83. All right, if there aren't any new comments, we'll move on to the next one. So that would be 30.84, titled Waiver when a loan is eligible for forgiveness based upon repayment plan. By show of hands, please indicate your consensus decision on 30.84. That one looks like full consensus. Next, we would go to 30.85. Waiver when a loan is eligible for a targeted forgiveness opportunity. By show of thumbs, please indicate where you are on 30.85 for consensus decision. On this one so far, in terms of dissent, we have Kira Taylor. Ashley, do you have a vote on this one? I couldn't see your thumb. Sorry. Thank you. That is the only one identified in dissent. On 30.85. If there isn't any new comments for 30.85, we would next move to 30.86. 30.86 is waiver based upon secretarial actions. By a show of thumbs, please indicate your consensus level on 30.86. I believe that one is full consensus. Moving next to 30.87. 30.87 is waiver following a closure prior to secretarial actions. By show of thumbs, please indicate your consent decision on 30.87. I believe we have full consensus on 30.87. If there aren't any new comments on 30.87, we'll move to 30.88. 30.88 deals with waiver for closed gainful employment programs with high debt to earnings rates or low median earnings. 30.88. Okay, by show of thumbs, please indicate your decision on 30.88. I believe we have full consensus on 30.88. Next in order is 30.89. 30.89 is waiver when the current balance exceeds the original principal balance. 30.89. All right, by show of thumbs, please indicate your vote on 30.89. All right, I'm going to identify those in dissent. Jessica Renucci, Gael Chavit, Kira Taylor, John Whitelaw, Sherry Gamage, Lane Thompson, Richard Haas, Wisdom Cole, and Sandra Bohan.
I think you missed Ashley.
I missed Ashley again. I'm sorry, Ashley.
Yeah.
I apologize. Ashley Pizzuti also is in dissent. All right, so that was 30.89. Are there any new comments on 30.89? All right, that moves us to 30.90. 30.90 deals with waiver when the current balance exceeds the original principal balance for low-income borrowers not in an IDR plan. By show of thumbs, please indicate your consensus on 30.90. Those in dissent include Jessica Renucci, Gail Shavit, Kira Taylor, Ashley Pizzuti, John Whitelaw, Richard Haas, Wisdom Cole, and Sandra Boham. There is a severability clause in 30.91. Do we need to vote that one separately? Or not? That's a question for the department.
No.
Okay. That leaves the FEL language. Are we voting on the FEL language in its entirety?
We are separating that out from A, C, D, E, F, and then B1, B2, B3.
So will there be separate votes on B1, B2, and B3?
Yes,
Okay.
sir.
Thank you.
Yes, sir.
Thank you. All right, so we are going to start with the FEL language, section 682.0, I'm sorry, 403. We're looking first at sections A, C, D, E, and F. And asking for your consent vote on A, C, D, E, and F first. Can we have a show of thumbs? All right, those in dissent. Scott Buchanan. Ashley, are you I can't see your thumb. There you go. Yeah, just a little higher. Your name blocks it sometimes. Thank you. Scott Buchanan in dissent. Sandra, did you vote? Sandra Boham? Couldn't see. Okay, in agreement, or 70%. All right. If there aren't any new comments on that section vote, we'll next go to B1 of the FEL language. All right. B1, by a show of thumbs, please indicate your consensus decision. We are on B1 of the FEL language. All right, I'm identifying those in dissent. Scott Buchanan, Kira Taylor, John Whitelaw, Richard, I can't see your thumb. Oh, you're up. Okay. And Sandra, I couldn't see your thumb. Okay. She's okay. She's in consent. Not blocking. Any new? Oh, Kira, yes.
So I just have one new comment that I didn't raise previously. I strongly support discharging the debt of commercially held FEL loans that are over the age of 25. My only reason for not providing consent here is because the cliff is present here as it is in the earlier IDR pieces of language. And I'm concerned that not all FELs would be encompassed even once they hit that 25-year mark. And so I just wanted to clarify my vote there. That is the only reason that I'm not providing consensus here.
Thank you, Kira. Lane Thompson.
I just wanted to add that the 20 and 25-year distinction for undergrad and graduate loans is confusing enough as it is. So to add in another that it's always 25 for FFEL just makes it even more complicated for borrowers unnecessarily. So I think.
Thank you, Lane. If there aren't any new comments, then on the B1 decision, we would next go to B2. All right, B2. Can we have our consensus decision by a show of thumbs? Looks like we have full consensus on B2. The next, and I believe the last final consensus decision is on B3 for this particular grouping. All right, B3 of the FEL language. By a show of thumbs, please indicate if you are in consensus or not. On B3 of the FEL language. Sandro, where are you on the B3 vote? You're muted.
The cohort rate, correct?
B3?
Yeah.
Mm-hmm. Yes, that is it. All right, I believe we have full consensus on B3. Are there any other items or sections to discuss now before we would move into the hardship discussion? We also may want to take a break as well. What's the interest of the group right now?
We would take a break now so that we would not interrupt the hardship discussion.
Mm-hmm. Okay.
So before we do, I'm going to ask indulgence. I have a hearing in 9 minutes and would wanted to make a brief introductory remarks before we get to the hardship discussion. And if there's no objection, I would like the opportunity to do that. I'm not asking that anyone respond to them, but I have a couple of things that I think is important for me to say. And if we take a break, I will be in a hearing and not be present for possibly the rest of the discussion, depending on how long this judge keeps me in his little courtroom. So with everyone's indulgence, I would like approximately 2 to 2.5 minutes if Ed and the FMCS folks and others don't object.
John, proceed, and then we'll take our break after John's up to 3 minute comment.
Okay, thank you so much. I want to take a step back. I am always enthusiastic and happy to join student debt negotiations on behalf of students with disabilities. I think there has been a long history, unfortunately, of not thinking about students with disabilities, and this stretches way back and predates many involvement of many people in here, going all the way back to at least 2013. Unfortunately, there is still a tendency not to think of the separate needs of students with disabilities, except when it comes to a specific disability-related matter, such as total and permanent disability. One of my hopes had been that my participation in this negotiated rulemaking session over the past 3 months would have to been resulted in a robust, actionable set of policies and proposed regulations addressing hardship. because that is the area of all the things that we've talked about that specifically would be relevant for folks with disabilities. There's not really a single word that we have had today up to this point that has been relevant in the separate sense for students with disabilities. Absolutely, students with disabilities will benefit from some of these changes that we have reached consensus on, and students with disabilities would benefit from some of the other proposals that were presented. But there really has not been a centering of issues revolving around students with disabilities. And again, I do not have any question about the good faith of the folks at this table, but my understanding is, just as an example, we were scheduled to do this for an hour and a half at the end, and we're now already down to an hour and 6 minutes. And after the break, it will be less than an hour. So I am troubled that at the end of 6 days of negotiations where we'd had previous discussions about hardship, we're not actually going to get something actionable for us to vote on. There are going to be no concrete regulatory proposals that come out of this that particularly address the situation faced by students with disabilities. And unlike a former colleague who made his remarks and did the mic drop and walked away, I have no interest in walking away from this table. I very much want to be a part of the
John, 30 seconds remains.
very much want to continue to be a part of the discussion, and I am not. This is the fact that I have to leave to go to a hearing. Please do not take that as any sense of lack of engagement. I want to be very much engaged in this as it relates to students with disabilities, and urge that the voice of students with disabilities be considered. Thank you so much, and with a bit of luck, I'll be back.
Thank you, John. We wish you a quick hearing.
Yeah, don't we all? Thank you so much.
All right. So is 10 minutes sufficient time for our break? All right, let's reconvene at 3:05 Eastern. Can we go off live stream?
Okay, welcome back. I hope that 10 minutes gave you a little bit of a breather. We are set to begin. We do have one of the researchers here with us to give us the presentation, and then we'll move into the hardship discussion. Before we do that, I'm going to turn it over to Tammy for a couple brief comments.
Thank you, Cindy. As you are aware, we did not produce regulatory text on hardship. The negotiators submitted a lot of creative ideas that discussed many types of borrowers, and we appreciate all the work that went into those suggestions. We reviewed that information, but we did not feel that we were able to craft regulatory text for this session. We understand the critical importance of hardship, and we are going to continue to consider how to identify relief for borrowers who need help, but who are not addressed by the current system or the proposals we have sought consensus on today. So we want to use this time to hear more about the ideas submitted by you all of you over the last several weeks, and of course our researcher today as well. We are going to carefully consider what we hear as we decide what our next steps on hardship should be. We have received a request from some negotiators for the presentation, and we will key that up in just a second. So we are providing time for that now. Then we will delve into what negotiators have submitted. So at this time, I'll turn it back over to FMCS for our presentation. Thank you.
Okay, thanks, Tammy. So in order to meet the non-federal negotiators' request for the presentation, I'm going to turn it over and let our presenter introduce herself.
Hi, everyone. This is Dalia Jimenez. I'm a professor of law at UC Irvine School of Law, where I lead the Student Loan Law Initiative at UCI. And I'm here to present to you work that was done as part of our initiative, and which I worked on, but I have to confess, I'm not an economist, and our economist main author, Marshall Steinbaum, who's a professor at University of Utah, just is actually proctoring his exam right now and couldn't make it. But I hope I will be able to answer your questions. Sultana Fauzia and Jonathan Glader also on this brief. So we were trying to answer the question of, trying to draw lines among hardship. I realize actually I'm not sharing my screen. I need to do that so that you see what I'm seeing. Here we go. Can you see I think you should be able to see.
Yes.
It. Okay, great. So this work is directly trying to answer the question that the department has posed about what types of hardships can borrowers continue to face, or may they continue to face, and how could the department address those cases of hardship? We used what we were already working on, which is the credit reporting data set held at the University of California by the California Policy Lab. And that data set is comprised of a 2% random national sample of borrowers who have an Experian credit report. And, it's a very large representative national sample. And we can only observe the kinds of things you observe in your own credit report. And so we can't speak to everything that, might measure hardship. This is sort of, we termed it sort of the tip of the iceberg, in the sense of like the things that are observable. There may be many other things going on. There are likely many other things going on that we do not have visibility into. And so here are the 6 main things I'm going to discuss with you today. We're looking at issues like the credit score. In this case, would be a decrease in a credit score would indicate higher levels of hardship. Decrease in the likelihood of home ownership, or really a mortgage. Increase in credit utilization, so having less available credit is an indication, in our view, of hardship. Increase in the number of accounts or people with severe delinquencies, which I'll talk about, but it's basically not paying for 3 months on an account. An increase in the percentage of legal adverse proceedings like bankruptcy, and increase in auto loan amortization, so growth in auto loan. So I will just kind of start with the punchline recommendation and then go into the slides with the graphs, which are all in the report. Our main recommendation, the first one, is to cancel student debt for borrowers in the bottom half of the income distribution of student borrowers. That is the bottom half of income, which corresponds roughly to incomes below $71,000. Importantly, we do not observe income in the data set. What we observe, however, or we have done is merge the data set at the with the American Community Survey data. And so we are essentially assigning income based on zip +4, sort of a small geographical area for a borrower. And the income in the American Community Survey data does not actually, distinguish between student loan borrowers and non-student loan borrowers. And here we're only looking at student loan borrowers. So what is happening is that, what is certainly happening is that we are under, we're over assigning income here, so that any recommendations that we are making are actually more conservative than they would be if we had income. The reason being that we know from other research that student loan borrowers have a lower average income than non-student loan borrowers. So again, the first recommendation is to reduce debt to 0 for borrowers in the bottom half of the income distribution, and then to reduce debt such that the student debt to income ratio for borrowers in the middle, sort of the middle income distribution corresponds to less than 30%, that student debt to income ratio, in that financially more than 30% debt to income is a hardship. Okay, so I'll start with some summary statistics and then delve into the 6 hardship topics that I discussed. You can see essentially that the median income has not changed very much. We're using these 2 snapshots in time as the pre-pandemic snapshot, the first quarter of 2020, before the payment pause, before the official declaration of, the pandemic, et cetera. So the first 3 months of 2020, we're comparing it to the latest data that we have in our data set, which is the second quarter of 2023. And here you can see essentially how we break out the incomes based on, again, our approximation of income using the American Community Survey. You may note that it ends, the sort of maximum income here is $250,000, which we know is not the maximum income in the population, but that's because of how the data in the American Community Survey is. They just, everything above 250 is just coded as 250. But we're not really making any recommendations about the top 10% of the income distribution. So to start with credit score, again, the idea here is that the higher credit score is good, lower credit score is bad. So a drop in credit score, if you look at the blue line, the bottom 50% income quintile, you see a dramatic drop for as soon as the student debt to income ratio gets anywhere past 0. Basically this is what, I would just repeat myself several times with the other graphs, which is that particularly in the bottom 50%, you can see here like a dramatic drop as soon as there is any student debt, which is why we recommend essentially for those student borrowers, below, again, roughly $71,000 in income and household income, that it would be a hardship to it would be a hardship to have them have any student debt, because you can see essentially pre-pandemic and post-pandemic the effect. And this is despite the fact that credit scores in general improved during the pandemic, as we know from, we can see here, but also we know from other research. And, mostly the idea is, the pause had a big effect. Credit scores in general improved, and credit scores for student borrowers in particular improved. I see a question, but I'm gonna hold it if that's okay, because it's gonna throw me off. Okay. Let's see. Okay. So, and then I can go back, like if there are questions, I can go back to any of the slides. So for home ownership, again, here what we're looking at is a borrower with a mortgage loan outstanding. And you can see the sort of, change, we're making these recommendations, you know, with, sorry, hold on 1 second. There's not, the thing about home ownership is that, you know, you have to have a certain credit score and you have to have a particular, you know, other characteristics in order to get a mortgage. So we don't see a lot of variation in the home ownership outcome for borrowers with a higher debt to income ratios. And there's almost no variation in the top 10%, as you can see, you know, the green line here. It's not, you know, having any student debt at all, though, you can see in the bottom 50% of the distribution makes a dramatic difference in whether or not you're going to be able to qualify for a mortgage. And again, this is why the major top line recommendation. Credit utilization. So this is about, you know, again, availability of credit, or rather the usage of credit. And there's no, you know, there isn't like a law about this or a general, you know, a rule written anywhere, except basically everywhere. The general recommendation or the general thought is that 30% or higher in credit utilization is associated with a declining credit score and difficulty with repayment. And so we view it as an early warning sign. And so by itself may not be, wouldn't be enough to make the recommendation that we make. But again, this is all in the 6 measures that we're talking about. And here you can, what we're doing is computing the total outstanding balance on unsecured lines of credit to the total limit across all the unsecured lines of credit. This is mostly credit cards that we're talking about. And you can see that like utilization, which is on the left-hand side, increases rapidly at the bottom of the range, in terms of the bottom, right? You hear that the colors are flipped where, the blue line is the bottom 50th percentile of income. And you can see how their utilization changes pretty rapidly as soon as they have any student debt. Okay, severe delinquency, we define, and actually this is not our only definition, this is the same definition that Federal Reserve uses, as having a loan with a payment of 90 plus days past due, so not having paid within 3 months if a payment was due. Most of the variation here is, again, in the bottom part of the distribution for borrowers in the middle, 40th% of the income distribution. This goes to our second recommendation. A student debt to income ratio of 30% appears to be a threshold for an increasing probability, and you can see that in the vertical line, the 0.297 vertical line, and observe essentially the red line, how it, there's sort of a jump there in 2023 and also in 2020, for that distribution. Okay. Adverse legal proceedings is the bulk of these are bankruptcies, but it also could include any other public records that the credit bureaus have kept track of. And there's not, the vast majority, over 90% of what we're talking about here is bankruptcies, but it could include foreclosure and alimony or small claims. And we're looking only at things that were filed in the previous 3 years, because all these public records can remain in a credit report for 10 years. So we're looking at things that occurred in the last 3 years. And here you can see again, there's much more sort of variation, but the threshold for sort of increased probability of facing adverse legal proceedings is, if we look at the blue line, the bottom 50% of the income distribution, and again the vertical dashed line of 0.97 or close to 30%, you can see that there's sort of a jump that happens much more dramatically in this case in the middle distribution, the 40th the 50 to 90% of income, the red line, But you can see it happening also in the bottom 50%, 50 percentile of income. Okay, and finally, before getting to questions, auto loans. So the idea here is we're looking at the degree to which indebtedness inhibits repayment or amortization of secured loans. And we use auto loans as the main example since the term is shorter and it's more similar to student debt than mortgages. And it's just, again, also something we can observe. We compute the average ratio of current balance on auto loans to original balance. So like how much have people paid down? And you can see that, auto loan amortization is much worse for borrowers in the bottom 50% of the income distribution if they have any student debt, while the amortization rates for borrowers in the top 50% of the income distribution is kind of independent of, of student, it's being affected by something else other than student debt burden. And this again, really motivates the recommendation to reduce student debt to zero for student borrowers in the bottom 50th percentile of the income distribution. I think that's the last slide. So I'll go back. I'll just put the recommendations up and then look at the chat because it looks like there are some questions from Ed. Hi, Ed. Is the median income used here national, state? It is the national. National is what we're using. Lawsuits for money owed, including student loans, have not been included on credit reports for several years. Since lawsuits don't include percentage. That's right. That's right. So we can't, we only have what we have, and it's Ed's comment on the chat is absolutely right. And we note it in the report that the credit bureaus can only include information if they can, actually match a public record to the person, to the person's credit report that they're reporting about. And that information is available for bankruptcies because date of birth and address and name are included. For most other public records, it isn't. We do observe some some non-bankruptcy things in the credit report still being reported. So I presume that they have, double check that. But yes, this absolutely means that we're undercounting. In many ways, like I said, this is actually a very conservative in the sense, as sort of the graphs that you see understate, to be more clear, understate the extent of the hardship, but that's sort of the best we've got. I've lost where everyone is. So I'm going to stop sharing for a second. I can reshare. It's just that I couldn't find you all. So, yeah, happy to answer other questions. Try to answer, to be clear, as the non-economist. I'm trying to see if should I just, Giulio looks like.
Yeah, first, thank you for the presentation and helping to ground the hardship conversation in just great evidence and showing us the extent to how student debt entangles in other economic insecurities. I wanted to, because I just want us to get some type of guidance because we're at we're close to the 4 o'clock mark. So I wonder if the facilitators can tell us how they see the last 30 minutes of the conversation going and how best to flow from here.
Yeah, we allotted the researchers 15 minutes. So if there are questions, Ms. Jimenez, did you complete your presentation?
I did.
Okay.
I just, if there are questions, otherwise,
yeah.
if there's my exit.
Right. Brady, how much time?
That was just at about a hair over 15 minutes.
Okay. So are there any questions that you feel you need to have answered while we have Ms. Jimenez here? Otherwise, we'll go directly into the hardship conversation. All right, I'm not seeing any hands. I want to thank you for joining us and sharing your research. on behalf of FMCS and the non-federal negotiators that requested your presence. Thank you.
Thank you.
Okay. Let's go into our hardship conversation. Tammy, anything you need to say before, or do we want to just go?
Yes.
Okay.
Thank you so much. As we move into this discussion, we wanted to provide some additional framing that would be helpful for us as we discuss hardship to highlight what would help us continue to review this issue. One is that as you discuss categories of borrowers, it would be helpful to understand more about the different thresholds or criteria that would be chosen. For example, there have been ideas around older borrowers or borrowers in default. It would be helpful to understand more about the rationale behind what age we should look at, or what's a proper amount of time to consider in default and why. It is also helpful to hear more about how some indicators might be used as a factor within a larger analysis. For instance, we do not think Pell Grant recipient on its own would be sufficient grounds for a waiver, but it would be helpful to consider how receiving a Pell Grant might be one factor among others. What other factors would you consider alongside it to look at hardship? The same is true for a joint spousal consolidation loan. How would that be used in a larger analysis, and why would it be used that way? Another thing to talk through is what data we would need and how we would get at it or get it. For example, we've heard some stories about borrowers with significant expenses related to caregiving or medical needs, but those factors are not included in the department's administrative data. The final thing to consider here is how to determine the amount of relief that would be appropriate given those factors and analysis. For example, borrowers might have different levels of medical expenses. How do we figure out how to connect the given hardship factor to what the amount of relief or what amount relief is appropriate? So with that, we want to turn it over for discussion.
Okay. Thank you, Tammy. Jessica.
Thanks, Tammy. There's many borrowers who have watched the proposals that we've discussed and voted on the last 2 days who don't see themselves reflected in any of the pathways to relief, even though their loans are really negatively affecting their lives. We've heard repeatedly that debt relief based on financial hardship is critical and urgent. We've heard it in the public comments, we've heard it from the negotiators, and we've heard it from the department itself, I think. But we didn't get any regulatory text, and we didn't get any specific feedback on a lot of the proposals that were submitted by negotiators. I understand that's what you want us to return to now. I wish we had more time, but we're looking at about 30 minutes left. Tammy, I know you said in your prior introduction that the department is still interested in working on this, but I think in order to take that statement seriously, we really need to know what the procedures are in order to get the department to issue regulatory text. My understanding is that the department can't issue this text without having discussed that text with negotiators. And I think, and I don't think the department disagrees, that we're the best negotiators to do that you're not intending to bring this at a new table or to convene a new negotiated rulemaking session. So I guess my question is, what are the steps from here? Are you open to extending the session today? Are you planning to reconvene the committee to discuss proposed text once you have it? If so, when are you going to do that? And how are you going to do that? And how are you going to let us know? And I think if you're not prepared to answer those questions, the real question I have for you is, how can you convince us and all the borrowers that are following live and in the news and are really hoping for relief here that they critically need, that debt relief based on financial hardship is still going to happen? I don't want to believe that the department's just walking away from this idea, but I'm just worried that if we end this session today without any concrete steps going forward, that's the only conclusion that I and others might be able to draw.
We
Go
are
ahead,
not
Tammy.
walking away from this. We're very committed to hearing what you have to say. We do have a hard stop at 4:15 today, but our plan is to listen to this discussion, to get the feedback that we've requested from you guys, and to share more about our next steps in the future. And that's really where we are. We need to hear more from you, and we'll be able to circle back at some later date with our next steps.
Richard?
before I share my concerns, I don't know, I see Jessica raised her hand again. I don't know if it's to continue that exchange. Yes and no?
Yeah, but you can go ahead. That's fine.
Well, yeah, I have to be honest here and really share my frustration with this. So when we were asked to spend a lot of time in our early sessions focusing on discussions of hardship, it was listed among the initial questions that began our NEGREG work in October, and we had literally entire days centered on stacks of questions about hardship as a priority that was established by the education department. We were told, we were directed and asked to go back and put together language proposal items for the department. And we were given this really tight timeline. I don't even remember what it was. We had like a negotiation session on a Thursday and we were told you needed language by Tuesday or whatever it was. We had literally 48, 72 hours to turn language around. And despite the short timeline that we were provided, we submitted many thoughtful proposals regarding hardship. We're being told now at 3:32 on the last day of negotiations, what is, purportedly the last day of negotiations, that we don't have language because you have follow-up questions. And I have to be really honest and say and question why we weren't provided the follow-up questions weeks ago if they were what was really hindering our ability to make progress on what was clearly identified as a priority for the department, for the negotiators, and for the borrowers who we are representing here today. I have to be honest, I don't understand why, if the only thing that prevented us from getting movement on this issue was the need for clarification on our proposal items, we were not asked for clarification on our proposal items. I'm sorry, I'm very frustrated that we were not asked those questions until 3:32 on the last day. And every time we tried to lean on the department and say, well, what do you need from us? What do you need from us? Where are we going with this? We just kept getting kind of pushed off to the side. I'm very frustrated. We've put a lot of time and energy into this. Hardship matters tremendously to this process. And I really, to reiterate some of the questions that Jessica just shared, I'd like to know what the next steps are for us and for the borrowers who are watching.
Okay. I see Ben Miller has come on camera. Ben, did you have something to say?
Sure, Richard, we appreciate that. I mean, one thing I would just say big picture is the questions we are reiterating here are very similar to the questions we gave at the second session. As we look to craft this, we have the same issues around trying to figure out data, trying to figure out prioritization, trying to figure out thresholds. There were a lot of really useful and interesting thresholds sent through to us. A lot of it came as reg text, so it didn't necessarily have the discussion behind it as to how or why those certain things are picked. And so, we are trying to understand a little bit more about what was shared as to how some of those things would be considered and would be picked. We are not giving up on this issue, but it is an incredibly complicated issue, right? A lot of the things we've talked about and sought consensus on so far today are talking about fairly categorical approaches, where our goal is not to get into individual borrowers and individual circumstances in quite the same way. A lot of these hardship discussions, there are some categorical elements, and there's also some more individualized elements. And, our goal here is automation. Our goal here is simplicity to the extent we can. And when you start to move into hardship determination, you start to move into more complex analyses, and that is a lot harder for us. And so what we are trying to do is we're trying to say, again, it's helpful to understand the rationale, it's helpful to understand the reasons. We have the same turnaround times that you do. Our goal here is to move this as quickly as possible. We are really excited about the votes we've taken today. We've gotten very useful feedback. We aren't done on this topic, but we are hoping to talk a little bit more here, circle back, and have next steps. As sort of Jessica alluded to earlier, we're not going to produce an NPRM on hardship without having text before a NEGREG committee. And so our goal here is to talk more, hear more, figure out how we could construct reg text or what reg text could look like before we have next steps. And so our hope is to hear more about the reasons, the rationales, why you draw lines where you draw them. And we're trying to say here for some of these things, we think that the things identified, whether it's spousal consolidation loans or Pell loans or things of that nature, Pell or things of that nature, those could be mitigating factors that go into an analysis, but we don't think they can be a standalone. So we're asking you how to think about comparing those things within a larger analysis, because this is an inherently more complicated issue, but we think it's a really important issue. So that's where we are, and this is us saying we're asking for more help. You know, that's just where we are right now.
Thank you, Ben. Jessica?
Thanks. You know, just to respond briefly, I don't doubt that you, Ben, or you, Tammy, personally, or the teams that you represent absolutely want this to work, but I don't see a way that we end up with hardship regulatory text without having a negotiated rulemaking. Ben just said that. I think Ben and I agree with the department here. And so my question is just, if this is a direction that the department is planning to go, how are you planning to get there if it's going to require a negotiated rulemaking, and when is that going to happen, and is it going to involve us? And I think that if you don't have answers to those questions, it really does make me question the department's commitment to pursuing this issue, because as much as you may individually want to do it, if it can't happen without a negotiated rulemaking and you're not willing to set a negotiated rulemaking, I don't see how it gets done. So thanks.
Thank you, Jessica. Lane?
I have a few thoughts here. The first one I'd like to mention is the hardship of loans that are not collectible. There was regulatory text submitted about this, and I think that any of the folks who signed on to that text would be more than happy to provide additional data, reasoning, and backup for why we did draft that. As part of that, I would like to mention that that is data that the department has access to already, right? What loans have you not been able to collect on for years and years and years? That can be looked at through benefit offsets. It can be looked at through private collections. It can be looked at through simple default data. The other thing I want to mention is that borrowers over the age of 65, that's a group of people that are generally considered to be elders in our society by lots of other governmental programs. You know, I think it would be hard to argue that people over the age of 65 ought to be paying back their student loans. Again, if this is something the department would like additional data, additional reasoning for, I'm more than happy to collaborate on providing that. The last thing I want to say just real quick is that we did just get that really excellent presentation on some of the hardship that folks face just from having student debt. And so I think that there's a part of this where canceling some debt for everyone or everyone under a certain income threshold seems to be a pretty clear and data supported solution. So the other thing I'd like to offer is if there's something that we're missing in terms of what would be useful for the department, you know, I'm sure that a lot of the other negotiators and I as well would be happy to continue this process into the new year.
Thank you, Kira or Lane, for those examples and offers. Yael.
Thanks. So a couple of things. I mean, first, there were some concrete proposals that I think maybe didn't require a lot of explanation that Ed got, and I don't think that we've gotten much of a sense into Ed's position on them or concerns about them, you know, including, for example, some of the proposals that Lane, the categories that Lane just mentioned. I brought up SNAP eligibility and Social Security disability receipt as indicia of hardship that the department could use because it's information that's available to the federal government and could be automated. You know, so I'm reiterating that, but I also don't want to lose the process point here, because it sounds like, you know, and first of all, I appreciate the complexity and the good faith. I think this is a challenging project you've undertaken. I'm thrilled that you've undertaken it, but I'm really concerned we're going to lose momentum as this session ends. You guys are starting a new NAGREG. And my question is the following. If what you need is more of an opportunity to have back and forth engagement with the negotiators, which, by the way, would be very helpful to see some regulatory text to facilitate that, even if it's not comprehensive, or to get a sense at least of the parameters that you're considering. It seems to me like that is a pretty good justification for scheduling another session. and potentially scheduling it out, farther, to a point so we can have a few days of conversation back and forth. But if you're saying that you need follow-up from the negotiators and we have half an hour left in the session today, I'm not sure what the next steps are, because we're going to have half an hour of follow-up. If we schedule another session, you'll have more of an opportunity to engage.
But just quickly on that, our hope was here to get to the substance rather than the process, but then to get to taking a look at it. And what we would do if we wanted to schedule another session is we would reach back out to this committee, talk about dates. I don't think we want to talk about 54 different calendars live on air. And then we'd also have to put a notice in the Federal Register talking about where the new dates are so that the public is aware. So what we're saying is we want to take a look at what we discuss here, and then we have a process if we wanted to add more time to discuss this to do it. And just to be clear, what we don't want to do is discuss further the things we just took consensus on.
Wisdom?
Thank you so much, Cindy. Just thinking back on this process, and I appreciate the remarks from the department, recognizing that hardship is an area, particularly for Black borrowers, young borrowers, and people that I represent within the organization, as well as the civil rights organizations that we are here representing today. Hardship is an area where we believe we can see the most amount of waivers or cancellation, as we've talked about, for those who are most impacted. I know we've shared countless proposals. I didn't see anything around those who are incarcerated borrowers, which is something that we definitely would love to do some more targeting. I think the conversation we've been having over the last couple of months has really been about making sure that we can provide relief for a target group or set. And I think this hardship area is able to do that. When we came talking about the changing of interest rate, you all told us that we'd push that to Congress. We talked about broad-based cancellation. You all talked about we needed to do targeted cancellation. I think that in this process, we should have spent more time talking about hardship and understanding the ways in which we can use this to best provide for the public. I do want to read just an excerpt just to remind us what the power of the Higher Education Act can do. It has the authority to enforce, pay, compromise, waive, or release federal student loans. And so I think when we think about this opportunity, we have to dream more in terms of the prospect of how hardship can be used to really see unforeseen factors. I hear you all talking about that it's harder to be able to capture the data necessary to put out some fair standards. The act of taking out the loan in the first place is the hardship, right? We can boil down specificities based off of different target demographics, but just from that first clear standpoint that folks are taking out loans because they do not have the ability to pay to go to school in itself is the hardship. And so for us to really make sure that this process is a sum total process that includes those who are in most need of this debt relief, we have to ensure that there is a fourth session or an opportunity to really settle this matter around hardship. And so I think that myself, as well as other negotiators that I've heard here, feel very strongly about that and need to make sure that we continue to have an open dialogue around it, but also see concrete text that allows us to discuss, to build, and actually produce a sufficient process as well as ruling that is encompassing of all borrowers.
Okay, thank you. Before we go to the next commenter, I want to direct you all to, there was a request for Tammy to put the questions in the chat. She has done so. So if we could focus this remaining time in this discussion around some of the topics that she has here, that they're looking for your feedback. One of the things is it would be helpful for the department to understand different thresholds or how different thresholds and criteria would be chosen. For example, there were ideas around older borrowers, which we just heard again about, and borrowers in default. It would be helpful to understand more about the rationale about behind what age they should look at, which I believe the statement was 65 or older, or what's a proper amount of time to consider in default and why. So if we could have comments around that, I think it would be most productive. Jalil?
Thank you. I can start with speaking on age and kind of the rationale of how I arrived to age. So multiple times during the session when I asked for guidance on hardship, I was told either that was coming later or I was referred back to prior rulemaking. One of the pieces of evidence I was referred to is how the department arrived to the federal poverty line of 225%. They did a data analysis on a data set. And so I aimed to gather evidence that did similar data analysis. I've sent the department a Federal Reserve study along with other research that shows that borrowers near retirement age, 56 and higher, experience hardship. One Federal Reserve study found that college attendees who still have student debt around retirement are no better off than peers who did not go to college. The small share of families in this category have not experienced a typical wage boost associated with a college education. So again, I used the same type of evidence that the department used to determine its federal poverty line, which was statistical significance. I sent it to them. Now we're being asked, can you clarify why you chose age? So I'm not sure what clarification or what additional evidence is needed there. So if the department can provide some more guidance or nuances questions, then we can know what type of evidence to provide. Because again, multiple reports were sent using the same type of evidence that the department has presented to us throughout the rulemaking session.
Okay, thank you. Jessica?
No, I think what I'm hearing from the department is that you might do something on this and you want to consider it in the future. And I'm confused as to what is going to help you make that decision. I think what you're essentially asking negotiators to do here is your job. You want us to negotiate against ourselves by providing specific thresholds on each of these metrics that would exclude certain borrowers, or talk about overlap between the factors that would, again, exclude certain borrowers. I understand that that is a role in the negotiations, but I think that we are not really at that point in the process when we don't have regulatory text. You also want us to look at the data, which again, I'm happy to do, but I'm not an expert on the department's data. I think the department is an expert on the department's data. I can't see what we're going to do in the next 10 minutes that could possibly change your minds about whether or not you pursue hardship regulation in the future. And, and I think that for me, and I think for some of my other negotiators, it feels performative. I think it feels like you want us to have said something about hardship so that you have heard it, so that you can say that you'll think about it and that there are really no next steps. And so, I was wondering if it might be possible to just take a 5-minute break, let the department talk, and then, come back and let us know that there are any next steps or that there aren't any next steps, and this is where we're ending.
So let me give a couple concrete ones, okay? So we saw the proposal from Kira about, I believe it was 3 years in default. As a general matter, most of our forgiveness programs are 10 years at the minimum, right? That's what we have in SAVE, that's how PSLF works. And so it'd be helpful to understand what is the rationale behind 3 years? How would you justify that when faced with the argumentation about, well, most of our plans stop at 10? That's the same thing with regard to Wisdom's suggestion around going from 10 years to 5 years for incarcerated borrowers. We are sympathetic to those groups. We would like to do something that focuses on groups like that, but it would be helpful to understand why 10 years versus 5 years and how you would argue that. What is the rationale for that? So for example, also, we heard a lot about caregiving expenses and medical expenses. I think that is a very sympathetic group that we would like to get to. So it'd be helpful to help us think through, let's say I've got $10,000 a year in annual caregiving expenses. Does that mean the whole loan is canceled? Does that mean part of the loan is canceled? How do you think about translating whatever that amount of caregiving expense is into what makes sense as a waiver? It's those types of things that are very challenging, especially because we have an existing statutory structure that has an income-driven repayment plan. So when you craft a rule, you have to think about, A, what is the rationale for the various lines you're drawing? And B, how do you respond to questions and concerns about existing statutory programs? I'm not saying the presence of IDR means you can't do those things. I'm saying you have to think about that. And those types of things are very challenging and very complicated. You know, we also, again, don't want people to get sucked into extended application. So it would be helpful for us to think about how could we find, what is the simplest way for us to identify people on SNAP? There's not a national database of people on SNAP. We cannot do just like a CMA to tell us who those people are. We do not have the ability to do matches with 50 states to get that information. So it's things like that that are challenging. And I think part of what we're asking for is, as you think about the broad remit of categories, which are the ones we should focus on first? We're not saying that just because you're not the first one, it doesn't mean we don't get to you, but we're trying to ask for help on what you see as the biggest priority, what's simpler, and where lines be drawn in certain ways.
Thank you, Ben. Kira?
So I can speak to the 3-year in default piece specifically. I think that is an opening offer from our perspective, 3 years in default, and having people trapped in a cycle of poverty where they're losing means that they need to pay for their housing expenses, medical expenses, childcare expenses, et cetera, is long enough that any longer than that is cruelty on the part of those borrowers. However, ultimately, the department has information. If the department needs more information about those borrowers, we know that those borrowers are disproportionately low-income folks. We know that they are disproportionately Black and Brown folks in this country. We know that they are disproportionately folks who didn't complete their programs. All of those things could suffice as a justification to say that 3 years is long enough. If that is not long enough, I would love a response from the department about why, because I think some of the challenge for us in responding to the department is that you've mentioned mitigating factors, that one of the things that we have proposed, even though from our perspective, that one threshold may be enough, is somehow not meeting a high enough threshold that is unspecified on the part of the department. Like others have mentioned before, I would have welcomed the opportunity to have discussions with the department about these proposals before these negotiations, because we only have 2 days to cover a lot of ground here. But like others, I think with 6 minutes remaining, we should talk about adding an additional session that is more targeted and more focused than how we've had these discussions so far, because we do need some limiting principles from the department, because like to Jessica's point, we can't really argue against ourselves here. Further, the department does have information that could justify cancellation here beyond the proposals that we have on the table, but the department has that data. And so I think trying to do hardship in a single brushstroke makes this unnecessarily complicated. This could be broken down into smaller pieces of regulatory language that could help focus the conversation moving forward.
Thank you, Kira. Ashley?
Yes, so I wanted to just clarify, there is a possibility of another session, but the department does not want to commit to that, correct? And then I have a follow-up for a group. One thing that I would
Ashley, I'm not sure that I understand that, because I'm and perhaps the department can clarify, but what I heard is they do want to follow up. They just have to follow regulations and look at what they can do next.
Okay, that's what I wanted clarified, that there is very likely going to be another session. They just don't know. Okay.
That is not what I said.
Okay.
All right. They have to look at what the options are. If there is a decision to have another session from this table, there are certain things that have to be met before that could even be done. Like Ben was saying, it needs to be posted in the Federal Registry so that the public knows. There has to be sufficient notice. The committee has to be done. 52 different schedules need to be pulled together. So that is what I heard the department say. Ben, did I misspeak that or mischaracterize that?
No, what I'm saying is we have the ability to add an additional session. We want to, well, I was hoping we were going to spend time on the substance here, but then figure out what we're going to do with that. And then, but the way to do that is not live on this screen, and it's through follow-ups. And, our hope was to hear more about, some of the questions I raised, take that into consideration, and then we have the ability to follow back up with people as we consider them.
Okay. Well,
And it's not
I have a
for negotiators.
great. Thank you
Ben.
for the clarification. I also have a group that I would like to discuss. And I know that there were new rules that were rolled out on July 1st for group discharge applications for borrower defense folks. Unfortunately, that is all caught up in the courts right now. So that is not moving forward, which the backlog of borrower defense applications are just getting piled on and piled on. The department does have the authority to start grouping those folks together without having the actual school groups to apply. And so I would like to propose that eliminating a lot of debt for quite a few people would be to start grouping those schools that have more than 200 borrower defense applications against them. I think that would help a lot of folks, especially since a large group of folks that went to those for-profit schools are low income.
Thank you, Ashley, for that that suggestion. Jessica?
Yeah, I just wanted to clarify, is the department saying there's some legal barrier to scheduling a new session now, or that you can schedule a new session now, but you don't want to for logistics, but you will later, or that you could schedule a new session now and you will decide at some later time if you're going to decide to do that?
I'm saying we have the ability to add an additional session. We would like to regroup from these 2 days and then decide in the near future what we want to do after that.
Okay, thank you. Jalil?
Yep. So I think that, I'm trying to follow the logic and pieces here. So while the department may, in good faith, came to this moment without presenting us questions prior and somehow hoped in an hour that we were going to be able to nuance and provide evidence and give data around proposals that we sent weeks ago, that clearly is not what can happen here because of time restraints. But it does seem like we are saying as negotiators, if we can get a clear sense of when a next session is happening, a clear sense of what are the questions and the additional knowledge or evidence you need in order to do whatever type of sense making you all need to do for regulatory text, we're able to do that. We are folks who are representing borrowers. We are folks who understand the technical and both the research and data pieces of the student loan issue. We have many folks that we're connected to who can bring the research and the people power to knock out whatever type of nuancing and additional evidence you need. But without presenting those questions clear, you're not allowing us to have just focused and committed time to give you the information you need in order to create the regulatory text that then would warrant another session. So to me, it seems like, can we schedule the next session? If for some reason we fail to provide what you need and you fail to provide a regulatory text, can't we just cancel it? But to not put one on the books when you have been sent many proposals and have had ample time to at least ask questions, I think would just be an injustice to the borrowers who again have been here waiting for cancellation, not just in this rulemaking session, but waiting for it from a Biden campaign, from a White House that has repeatedly put forth ideas and confusing and contradictory information. I think this is just another moment where there's such a clear chance to do something, and we're instead saying we can't do something because you don't have clarification, even though you have some of the greatest minds and experts on student debt right here and telling you that they're willing to show up again. It's just a missed opportunity, and I think a grave injustice not to schedule that at the very least.
So we hear you. We know you guys want us to come out with a formal position that we are going to have another session. Ben has addressed this on 3 separate occasions during this conversation. We cannot come out right now and say any more details about what is going to happen. We need to go back. We need to regroup. We have protocols. We have procedures that we have to follow. We have logistics that we have to look at. So I apologize if that is the best answer that we can give you, but that is the only answer we have right now. So we have several minutes left. We can either look to answer, and we know you've given us proposals. We know you've given us things to think about. Our researcher gave us things to think about. We are going to go back and we are going to look at that. And if we have follow-up questions, we will communicate to you guys when we know what our next steps are. But we cannot commit to anything at this moment because there are too many factors that we have to work through first before we can come out and officially say anything more. So unless there's any additional conversation, we can go ahead with our wrap up and close out for the day.
I have to respond to that. Tammy, I think if what the department is saying is that you came here today with additional questions, you needed more nuance, you needed more information, then I think we can spend the last 7 minutes with you at least posting those questions in the chat, at least presenting the additional information that you need, and creating an opportunity for us to be able to send whatever it is that you're claiming you still don't have yet. So we can spend 7 minutes of you all just telling us what you still need. Because I think right now,
So I think what we're going to do is we're going to say thank you so much for serving on this committee. I have a few comments that I'd like to close with today, and we're going to wrap it up. We will communicate with you when we know
Tammy,
additional
but
steps.
I don't appreciate you interrupting me. I didn't interrupt you, and I don't appreciate you interrupting me. I asked a very fair question about a good faith negotiation, and you could have answered it. Don't interrupt me, particularly when, again, we're talking about borrowers who should have more respect. And that's
Okay.
all the Department of Ed.
All right. Thank you, Joel, for your comments. We're going to go ahead and wrap this up for today. Tammy, you want to give your closing remarks, and then the department will do, FMCS will do the same.
Absolutely. Thank you. Congratulations, Student Loan Debt Relief Committee, on completing the third session of these negotiations. It is an incredible accomplishment, and we appreciate the hard work that you all have put into the success of these negotiations. We would be remiss if we did not properly thank everybody. To our FMCS partners, non-federal negotiators, the public, every ed team member, specifically our auxiliary services team and technical team that handle behind the scenes logistics, the Office of the General Counsel, Office of the Undersecretary, Office of Post-Secondary Education, and my team, the Policy Coordination Group. It's impossible for me to call out every individual or group that assisted in making these negotiations a success. But the heartiest thank you for your participation and/or contributions to the student loan debt relief negotiations. This incredible endeavor would not be possible without you, your dedication, and your hard work. I hope you agree that despite several months of hard work, you've worked diligently in assisting in the development of proposed regulations for the Secretary's authority to waive student loan debt. Each of you have represented your constituency group well and should be proud of your work as a non-federal negotiator. It's been my honor and privilege to serve as the federal negotiator and to work alongside each one of you in this valiant effort. Non-federal negotiators, you've given the department solid ideas, which will assist us in drafting the NPRM in the coming months. We will consider the comments heard today on hardship and follow up in the near future with how the department is deciding to address this issue going forward. We did not reach consensus on all the proposed amendatory text. However, the items where consensus was reached provide great benefits to our borrowers. I am most proud of all the work that led to these results. The department will take back the informative discussions on the sections where consensus was not reached and propose regulatory text in the notice of proposed rulemaking in the coming months.
Thank you, Tammy.
On behalf of the department, we appreciate you serving and the incredible work that you've done over the last 3 months. Thank you again, bid you fond farewell and a joyous holiday season.
Thank you, Tammy. Scott Buchanan, do you have something real quick?
Yeah, just I had a really administrative question. So Tammy, we do expect that the results of our consensus and negotiation today, there will be another opportunity. I just said this maybe is more of a statement to the public to comment on that. If there are additional things, and y'all are still expecting in May of 24, according to your regulatory calendar, is when we're expecting to see that for public comment.
So I'm not sure that that's the right date. We are going to work on this and try to get the NPRM out as soon as possible. I know that there was a unified agenda that was published, but I'm not sure that was the most current unified agenda. So that's above my pay grade. So I don't really know the answer to that question, but I can't commit to May, but I can commit that we will definitely communicate out, and we will communicate to you on the areas in which we received consensus. You'll be seeing those parts of the NPRM. So hopefully it's sooner rather than later.
Thank you. So on behalf of FMCS, I do want to commend you all on a very long and diligent several months here that you have dedicated your time and expertise to assisting the department in moving some changes forward that will benefit the student loan borrowers. We appreciate being a part of it. This is not an easy task, and this is not one of the easier regnegs that has been approached. Okay. So you all need to be very proud of the work that you did and the advocacy that you've done for your constituencies and department, for listening to these people and offering the opportunity for this collaboration and engagement. We look forward to further communication on if there are next steps in the circle back. We'll be happy to do what we can moving forward. So with that, I want to thank you all and call an end to this negotiated rulemaking, and congratulations on a number of consensus areas that you did reach. Thank you.